You accept your responsibility now that we saw it on a video.
There is also the footage from the inside of the car where both are detained, where she actually speaks to the other defendant without the cops being there, and she talks about how she was here and you had told her not to do this anymore. But I think that first video kind of sums everything up.
All right, any evidence with regard to count 1 before I make my finding?
Evidence, Your Honor, present testimony.
And anything that could...
I'm looking at this trying to figure out if that's a legal search. I mean, she appears to be detained, so it's not a Terry search. It's a warrantless search, obviously. She's not under arrest and being searched at the jail.
They didn't search her. They said, if you have something, take it out. She took it out and she placed it on. They didn't even have to get to the search.
I guess she could have refused and remained silent.
But she didn't, and
She
so...
followed the direction. And there's no Miranda issue since she wasn't
Right.
arguably in custody. I don't have any argument. I will go ahead and object if that's an illegal search.
All right, that objection's overruled. I am going to find count 1 true. And so, let me see, I need to... Counts 2 and 3, she pled true to, so there's a finding of true. Count 2, again, everyone's had an opportunity to review that pre-sentence report. Mr. Kimler, you may make argument with regard to punishment.
Yes, Your Honor. At this stage now that the state has offered evidence as to count, as to the new offense, and the court's found that to be true based on the evidence, I think that the recommendation comports with the state of the record. I would again defer to the probation department, but I think that they're seeming to indicate that the court is to keep her on probation, that she enter into the ISF program, cognitive track, and I would defer to that recommendation in lieu of revocation.
Mr.
A proposal, I suppose, I don't know if it's an actual.
With the pending charge of this theft, she's not eligible to go to ISF.
If I may, she's set on that today. I can resolve that today in this court.
No, it's pending in felony court.
It's here,
Oh,
it's
is it here?
mine.
Okay.
Because it's a prior
All right.
thefts.
All right.
She's done with misdemeanor
Right.
thefts.
We could resolve that perhaps today, Your Honor, if the court.
I mean, I'm, go ahead.
The state, I feel like we have given her every possible chance to rehabilitate, and she has not taken that. We would ask that she be revoked and given, based on the number of thefts committed, that she be revoked and sent to the state jail for 2 years.
Ms. Lopez, do you have anything else to add to your updated
No, I put
report?
everything in my recommendation.
All right.
Do you want to address the judge?
Yes. I feel like I did, how can I say this? I feel like I can finish my probation off because of the simple fact, like, this is the longest I've been away from my kids besides when I did 8 months, but they was younger than me, and like I was younger, and like they understand what's going on. And I understand, and like me being away from my kids right now is really hard because they be with my mama, and my mama had dementia, and she...
Stop with everybody else, because I'm not going to make my decision today based on the fact that you have kids or based on the fact that your mom needs you, because you weren't thinking about that day. So don't put that on me,
No,
that if I send you to prison, that I'm somehow going to be hurting your kids or hurting your mom. You've done that. You were on felony probation, and it sounds like if the other video was played, you knew exactly what was going to happen. If what Mr. Smith is saying is true, that y'all were in that car and you said, Judge West said, I better not do this again, and you did it again, it just makes me look like an idiot for giving you the opportunity in the first place. At some point, you have to stop. At some point, you have to stop. Anything else?
Judge, even based on what she told probation is, she wants to be reinstated on probation. She was just with the wrong person. The girl she was with already took probation.
Right.
I wasn't the one stealing.
Yeah,
So she
I made a
doesn't
note of that.
accept responsibility.
How is this my responsibility?
You accept your responsibility now that we saw it on a video. You didn't accept your responsibility. You said you were with the wrong person. I'm gonna tell you like I tell everybody else. You are the wrong person. She was with the wrong person. Y'all were with the wrong, you're all, if you're in there doing it, you are the wrong person, right?
Yes, ma'am.
So you didn't take responsibility. You haven't taken responsibility. You were given this opportunity after having felonies and going to state jail for the same offense, and I gave you a probation, and I said, don't do it again. So at this time, I'm going to find again, count one, that there was sufficient evidence to find count one true, find it true, find that you pled true to counts 2 and 3, find sufficient evidence to revoke your probation, and at this time, revoke your probation, sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to...
I'll get the other one worked out today.
Okay, I'll hold it while y'all do that, and then while I'm doing that, I need a, I'll hand you the trial court certification in just a minute after y'all do that on this case that shows this was not an agreement. You have some limited rights to appeal. If y'all want to go visit about the other one, I'll hold it. All right, go ahead, go back that way. The motion.
Here we go.
Mr. Henderson, in clause number 22-40931, I have a motion to revoke your community supervision. Shows that you were placed on probation June 13th of 2023 for the offense of unlawful possession of a firearm by a felon, and that was a 5-year term in prison that was probated for 5 years. Is that correct?
Yes, ma'am.
The motion alleges you violated your probation. Count 1 alleges that you committed the new offense of aggravated assault February 26th of 2025 in Montgomery County, Texas. And is that true or not true?
True.
Count 2 alleges that you committed the new offense of unlawful carrying a weapon in Montgomery County on February 26, 2025. And is that true or not true?
True.
Count 3 alleges that you did not provide verification of performing the community service hours as required. And is that true or not true?
No, that's not true. I did most of my community service.
Okay, that's fine. Count 4 alleges that you are behind in your court-assessed fees. And is that true or not true?
True.
Count 5 alleges that you failed to remain in the state of Louisiana and that you were in Montgomery County on February 26, 2025 without permission.
True.
Count 6 alleges that you failed to report to the Jefferson County Probation Department by mail-in or online for the months of October, November, and December of 2024, and then January and February of 2025. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, 4, 5, and 6 freely and voluntarily?
Yes, Your Honor.
And did you plead true to those counts because they're all actually true?
Yes, Your Honor.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, Your Honor.
Do you fully understand them? Well, the agreement that you made with the district attorney that you will be waiving or giving up any right to appeal.
Yes, Your Honor.
State,
Just so the court
Yes.
is aware, he received 2 years on the case in Montgomery County. That has been disposed of according to their office.
okay, thank you. State tenders number 1.
No objection.
It's admitted any evidence that Mr. Henderson's not competent.
All right.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that your plea of true to those counts freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of those pleas. Find counts 1, 2, 4, 5, and 6 true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. That sentence will run concurrently or at the same time as your Montgomery County cases. I have handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir. You can go back with the bailiff. All right, you're Kaylin Salzar, and in cause number 24, DCCR 2234, and that is for a misdemeanor offense or a case that was reduced to a misdemeanor. It's an unadjudicated probation. She was placed on that probation, April 21st of this year. And it was a criminal mischief that was reduced to an attempted criminal mischief. A motion to revoke has been filed, or motion to revoke unadjudicated probation. It alleges a DWI from August 23rd of 2025. It alleges a failure to report in August, failure to perform community service, behind in court assessed fees, that she admitted to using alcohol in violation of her probation August 23rd of 2025, that she has not completed a cognitive thinking class as ordered. And in addition, we have a pending felony case of her getting the probation in this case, and so that's not alleged, and it's standing, I guess, on its own at this point. Mr. Kemmler has filed a motion asking that I set a bond in the misdemeanor probation case where she's on an unadjudicated probation. Mr. Nichols, what's the state's position on that?
Your Honor, in addition to the two cases before you, she has two separate DWIs that are pending lab results that have not yet been filed. One is from March and predates this probation. One is from is what's listed in the motion. It looks like the only thing holding her is the bond on this case. And if she's in light of those arrests and what's alleged in the motion, if she's going to be granted a bond, ask there be interlock. And
I would suggest she not be allowed to operate a motor vehicle, period, instead of an interlock. If she does have the interlock, I don't think she needs to drive at all. But she wants to go into rehab, Your Honor, and that's really the purpose of me trying to get her a bond. Where have you talked about it?
Well, and here's the thing, you don't get to pick all of that. She's on probation, so that has to go through probation. In addition, we have another case pending, everything I'm not just going to put off. And so obviously if there needs to be some rehab, then I'm all for that under the right circumstances. But if you make a bond, you can't just go off somewhere without it being approved by probation and ultimately by me, and so that we know what that is, where it is, and what that means with regard to that assault on a peace officer case.
That's her intent. She does recognize that she has an alcohol problem. I've talked to her extensively about that.
Hold on a second. So, Mr. Nichols, any other input?
if it's not going to be, and I agree that maybe her not driving at all is probably the best course, but there needs to be some sort of monitoring, like a scram or something along those lines.
I agree. So what I'm going to do, Ms. Salzar, in cause number 24, DCCR 2234, is to grant that request for me to set a bond. I'm going to set the bond at $10,000. Condition of that bond is you are not allowed to drive anything, no vehicle, period, ever. You will be required to wear a scram device. Obviously, if that tests positive, then you will be in violation of your bond conditions. That bond's going to get raised, and you'll be able to wait all this out while you're in jail while it gets sorted out. You understand? Any other conditions?
I think that should cover it, Your Honor.
Okay, and so what I'll do then is we'll reset, a normal reset, and see what we need to do on this, obviously, as well as the other pending felony.
And then she needs to report to her probation officer as soon as you make bond.
Yeah, you're still on probation, so go straight to your probation officer, talk to them about what you need or can do, and then go from there. Okay.
And so we touch with your bonds.